Hello, my name is Natalia Willette, and I'm an attorney here in the state of Florida, and today we're going to be talking about divorce. In a couple of my prior videos, I've talked about something called the best interest of the child, and I just wanted to go in a little bit more about what is in the best interest of the child in the state of Florida when determining timesharing or custody. So like I said, there's over 20 factors, but I wanted to go over a few of the most important ones. So number one, capacity and disposition of the parent. How capable are they in taking care of a child? Do they have any disabilities of their own that make it difficult for them to take care of another person? What's their disposition like? Are they of the type of demeanor that can handle being around young children, teenagers, etc.? Those things get taken into account. Number two, truthfulness to the court. How honest has this parent been in their filings to the court? How have they been in their demeanor in communicating to the court about the other parent? Have they been dishonest? Have they perjured themselves? Those things get taken into account. Number three, domestic violence. That's huge. If there has been domestic violence in place, or arrest for domestic violence, conviction for domestic violence, all those things are going to get weighed in, because the last thing the court should be doing is awarding time sharing to a parent that might be a risk of harm to the kid. Number four, the needs of the child. Needs of the child means, obviously, children have basic needs, right? So they need food, they need lodging, they need to be able to have access to education, those things. But it's also talking about special needs. So if your child, for example, is allergic to gluten, does the other parent understand what that means when it comes to feeding your child who has special needs? And then number five, geographic viability. You don't have the ability to prevent your ex-spouse from living anywhere in the world that they want to live, but a court has the ability to make a determination as to what is in the best interest of the child in terms of geographic viability. You can't have 50-50 time sharing if your spouse lives in Seattle and you live here, because your child needs to go to school, right? So it needs to be a geographically viable plan. So those are some of the most important factors that I wanted to discuss with you when it comes to the best interest of the child. If you like this video, if you find it of value, then please subscribe to our channel. And remember, divorce is not the end. Divorce is a new beginning.